It's now, what, a year and a half since our bill on provisions in respect of pension entitlements for retired workers passed second stage in the Dáil. What it's about is saying that retired workers cannot be ignored, cannot have their pension pots raided without a consultation. It passed second stage, but the government put a 12-month stay on its progress to have a consultation period. We're now 18 months down the line. The government has proposed nothing, brought forward no alternative, nor signalled whether they will support the substantive aim of the bill or not. My question is to find out if they're going to.
Thanks, Chair. Again, thank Deputy Murphy for raising this issue, and again, I would have discussed this with your colleague, Brian Murphy, on a few occasions as well. And as you know, we do have difficulties with the bill, as we put on the record on the first night in the Convention Centre when we discussed it as well. At that second stage debate, the five members' bill on industrial relations provision in respect of pensions entitlements of retired workers, I outlined the Department's difficulties and concerns in relation to the proposed bill, as it was then drafted, and why it could not be supported by the government. If a person is in receipt of an occupational pension, their relationship is with the trustees of the pension fund. Then they no longer have an employment relationship with their former employer. And as the Deputy will be aware, trustees have statutory and fiduciary duties to act in the best interest of all members of a fund. It is the responsibility of the Office of the Pension Ombudsman to act as an independent and impartial means of resolving complaints alleging financial loss occasioned by an act of maladministration and disputes of fact or law in relation to occupational pension schemes and personal retirement savings accounts. It is important to note that access to the industrial relation machinery of the state, which is what your bill is asking for to happen, including access to the Workplace Relations Commission, is governed by Section 23 of the Industrial Relations Act 1990. This legislation provides that a worker means any person aged 15 years or over who has entered or works under a contract with an employer. A person in receipt of an occupational pension is not a worker and therefore cannot have a complaint dealt with by the Workplace Relations Commission. In March of this year, our department launched a public consultation on this issue of the retired workers' access to industrial relations, and the submissions received are available as well to work through. And why did we have that launch? I did commit with Deputy Brian Murphy as the sponsor of the bill 18 months ago that while I didn't think the bill you're proposing could address the issue you wanted or was the right place to do it, and we had sympathy to try to find a solution to give greater access. And I would have met some of the groups involved in making the legislation with you and committed to doing a public consultation to see what the views out there would be, or to see could we find a way to do this, because we're not convinced that your bill is the answer, and I've been honest with that from day one, and we're still not convinced. So the public consultation was there are submissions, and they're open to yourself as well to work through to see if you want to make changes to your legislation before you bring it to the next stages, or if we can bring forward some other solutions. For our part, we have shared with other departments to get their views on those submissions as well. Can we assist here in some way?
We campaigned for years by groups which represent over 500,000 retired workers. It's 18 months since this bill was debated at second stage and passed by this House. But the Minister is just saying that, oh, we'll have a consultation. I mean, do you accept there's a problem? Do you accept that it is a problem that 6 months after you retire, you've paid into an occupational pension scheme for all your working life, then you have effectively no say in any proposed changes, no effective mechanism to air issues or seek redress, and effectively your pension can be raided. It can be negotiated away and you have no input into that whatsoever. You have no right to be consulted before any of those changes. So your income can absolutely be slashed. Do you accept that there is a problem there that needs to be addressed? And if you don't think our bill is the way to do it, okay, but then what are you going to do? And the idea we're going to have a consultation or whatever, that's just kicking the can down the road at this stage. If you had said this 18 months ago, okay, fine, but a year and a half has passed and it's not even clear if you accept that there is a fundamental issue here.
Deputy, maybe you didn't listen to my answer. Maybe you come in with some pre-prepared conditions on what you were going to say yourself. I very clearly said that, following on from the commitment given to your colleague on the floor of the Convention House, that we would explore this to see could be help. We fundamentally disagree with your bill because you're changing the relationship of industrial relations discussions and negotiations, bringing in a third party that are not still working there. So I think we disagree on that, and that's not going to change, to be honest with you, because we can't see how we can facilitate that. But I did say to your colleague that I would engage with her on foot of that bill and the arguments she made. We met some of the groups involved, And again, we said we'd have a public consultation, which we've had, and it's over. And the submissions have come in. I'm saying those submissions are available to you and anybody else to look at, to tease through. We've engaged with other departments to also look at those submissions to see, is there any change that can be done here to strengthen the position of retirees and pensioners? It might not be our department to lead on that, because it doesn't really fall to us to do this. While I have understanding of a situation and what they want to address, we might not be able to solve it in our department, and we might have to work with other departments as well. But currently, and Chair, just to put on the record, in the context of any changes to pension benefits payable from a scheme, the employer and the trustees of a pension scheme are required to notify scheme members, beneficiaries and authorised trade unions. Changes made to the Occupational Pension Scheme Regulation 2015 require trustees to also notify a group representing the interests of pensioners and deferred scheme members in these situations. And that gives them the opportunity to have their say at that stage. I understand from your groups they don't feel that's enough. Sorry, Chair, it is complicated.
I heard exactly what you said, Minister, and you repeated it there. We're going to explore to see if we can help. That's great. 18 months after this was brought very firmly to your attention, and then say we have to see if there's anything that we can do. Like, you've had the consultation, you've said that. Well, do you accept that there's a fundamental problem here? Do you accept that it's fundamentally unjust that workers have had their pension schemes raided both by the government and by private sector employers, and that deals done have had profound impacts on retired workers at a vulnerable stage of their lives, on which they had no prior consultation and no ability to impact on? Do you accept that that is a fundamental problem? And you make the point that, well, as the law stands, retired workers can't go to the WRC, but we get to make the law in this place. It isn't a defence to say, well, as the law stands. That's precisely the point of amending the law, is to say that workers should have access. Retired workers, pensions are deferred wages. Retired workers should have access to the industrial relations machinery in terms of being able to go to the WRC. It doesn't affect other industrial relations machinery. It simply says that they should have a voice in any proposed change that impact on them.
Thank you, Deputy Minister.
Again, Chair, just in case there's any doubt, it's your piece of legislation. I'm not stopping you bringing it back through the committee and following the usual channels. There's nobody blocking you doing that. You're totally free to go and argue your case and bring it through the system. Nobody's blocking you on that. What we said as a government was we don't agree with your bill. We think it's a flawed bill. It won't solve the problem you want to solve, but also it will complicate industrial relations machinery that we have that operates extremely well, because you're bringing in people who have left the workforce to have a say on existing situations within the workforce. So we don't believe that that's going to help. In relation to the law, I mean, the role of the Pension Ombudsman is already there in the meaning of Part X11 of the Pensions Act, is to act as an independent and impartial means of resolving complaints alleging financial loss occasioned by an act of maladministration and disputes of fact of law in relation to occupational pension schemes and personal retirement savings schemes. So there is legislation there. We're not the parent department for it. I understood when I met the groups particular concern that they feel they're left out or they're not consulted at various stages. My interpretation of the law is that they are consulted, but they feel they can't put an agenda on that, or they're consulted, but they're not listened to. And that's where I said there possibly is the case to strengthen the legislation. Your bill is not the answer. And I don't think you want to hear that, but if you believe it's the answer,
I just want to hear you to have an answer.
Thank you.
You don't even have an intention to have an answer, is the problem.
Concluded on this particular question. We'll move on to question.